Party, Inc. versus Pima County et al. This is the time set for oral argument. Each side will have 20 minutes to argue the side. The appellant, Mr. Reisner, if you'd like to save time for rebuttal, we will let you manage your clock. But it's in there, and you will have that in this matter. As you come forward, please identify yourselves and decline to represent. So if we're listening to the audio tape later, we will have no questions about it. We have read the briefs. We've conferenced this matter. We think we have an idea of the issues involved. As another, we had a request that had been granted to have this audio tape by Mr. Howard Fisher in his official capacity, and that has been granted. So with that in mind, counsel?
Thank you, Judge. I'm Bill Reisner. I'll be arguing for the Appellant Libertarian Party. My co-counsel, Ralph Ellenwood's here. I hope that, or at least it's my plan, to perhaps save 10 minutes for rebuttal.
Okay.
So may it please the court. You know, this is, I think, a simple case. It involves our most important right as citizens, the casting of votes and the corresponding counting of the votes and the obligation that that count to be accurate and the ability of the court system to assist in the preservation of the rights of our citizens. It's my honor to represent a political party. The Libertarian Party is, you know, one of, I guess, 4 parties that operate statewide. And in Arizona, political parties have the primary responsibility to monitor elections. Our elections are run by county boards of supervisors. The counties have a small staff. And I think in Pima County, there's something like 3,000 citizens that assist at the polling places and at other locations, all to see that the chain of custody is maintained, that the elections are run properly, because of the importance of everybody having confidence in the results of the elections.
There's been a lot said in the briefs back and forth in this case about what remedy your party, your client, is seeking.
Yeah.
Let me see if I can summarize my understanding of your argument.
Yeah.
As I understand it, you're saying we need to go do some discovery. The discovery may reveal something that the court can address in an appropriate injunction. Is that about right?
Actually, there's not much of that. We, I think, need some would need discovery to prove a predicate, which is that they in fact fraudulently rigged an election. That's part of the process in order to be able to get an injunction. But we certainly have evidence and witnesses with no discovery really little from our side in terms of showing what changes, what the court could order to make sure that it's correct. Right now there's a black box, and there is no auditing of a single ballot, not a single ballot for any county race or bond election is ever audited. It's simply somebody pushes a button and a piece of paper comes out and they say, here are the numbers, here's who won and here's who lost. You don't know if the machine counted wrong, if it was programmed wrong, none of that. And both sides agree, certainly Pima County has agreed in the past, that, that the black box, that the computer can be rigged in so many ways. There's a variety of ways that an election can be rigged. There's just a bunch of them. I could go through the list, but there are known ways to audit and to counter those things. And certainly once we prove our entitlement, which would be that we show that an election was rigged, then we can show, look, here's a change that can be made.
Would you also have to show that there was not only a rigged election or some such serious kind of finding in the past, but that there was a probability that it would happen again in the future?
Well, what we can show is that it is easy to rig them, and there's nothing you can do about it. And so that's the problem. In terms of probability that they would do it in the future, I think you simply look at the situation, and it would be no different if you were running a bank and someone stole money out of the vault because you didn't have an accounting system, and you say, gosh, they got a couple $1,000,000. What's the probability they might do it again if they can do it and never get caught? I think we can rely on human nature and someone saying, gee, they know better than everybody else, and here's what the result ought to be. So really the issue is not the probability, it's the ease that elections can be rigged and the inability to do anything about it, to prove it, to audit it, check it. It's just not there. That's the key problem.
Have controls, for want of a better word, in advance. Once you have the election, you can't tell.
You have to do everything in advance, everything in advance. Afterwards, it's on, it's sour grapes, there's this or that, you don't look, you really can't do it. The only thing you can do afterwards is this narrow band if you find out within 5 days and can specifically do something. But we're talking about computers, and it's one of the interesting things that those who know the most about computers are the least happy and the least willing to have them name the results. And it's the case where, since the Board of Supervisors run it, and truly, you know, I have testimony from the Secretary of State that says they have no authority to check on what goes on inside any computer, and never done it. No one in the state of Arizona, from any county or any the Secretary of State, has ever looked to see whether that computer's counting right. They haven't done it, but Secretary of State says they don't have authority to do it. Secretary of State has rules to protect the machine from hacking and from being manipulated. They say they don't have authority to even look to see if the county's following the machine. That's their sworn testimony. So
can you give us a little more description of what the remedy would be here if this was allowed to go forward?
Oh, there's a variety of them. There's a basic remedy, for instance, if the county would segregate ballots, particularly early ballots that are mailed in. 70–80% of the ballots are early ballots. If they're simply segregated by precinct, just segregate them by precinct, then and then do a random audit, then that number is found somewhere in the canvas. Right now, the number's not found anywhere in the canvas. So, and right now, there's not a single audit of any county race. Nothing. Nothing. 70–80% of the votes are mailed in. Machine counts them. Boop, here's the result. There is a minor, which good, really. Some people that have been involved with this suit helped push this through the legislature. There is some auditing of they randomly select votes counted at precincts for, let's say, governor or president or Congress, something like that. But no county races. No county races are ever audited. So whatever it says at the precinct, There's no audit to see if they were counted correctly. And the machine can be programmed to count wrong. There's what's mailed in, there's no auditing. There's no auditing done there. We certainly suggested, and I put it in the in a disclosure statement that I filed concerning graphic scanning. That is all our experts say that is the #1 answer that ought to be considered by a court. It's never been argued or presented or anything like that.
And by the way, when you say graphic scanning, you're just talking about taking a picture on a computer of every page, right?
Yeah. What happens is it's
different than ordinary scanning.
Yeah.
Didn't know what graphic scanning meant as opposed to ordinary scanning of documents.
Yeah, I think what it is, there are these things called high-speed commercial scanners. And where it's been done other places is the election department would count the ballots in one place. It's all, you know, that they do. Then those same ballots go over and they're scanned through like 20,000 in a graphic scan system. And then there's a couple programs where it's an independent program that can then analyze those results, that scan, to see if it matched up, and if it didn't, figure out what happened. There was one in California, a county that did that, and at the end they said, gosh, here's a bundle of 191 votes that isn't on the regular canvas. They looked, found, oh, it's a glitch in this particular software, and they were able to discover that. So that's it's really an elegant, good answer, but it's only one. There's a variety of things. Once the court would look and say, okay, how are these ballots handled? Computer experts say, here's the problem. Here's what this can go wrong. This can go. Okay, well, what's the answer that we can be sure that the result is accurate?
What's your response to the other side's argument that well, and I'm going to probably badly paraphrase their argument, but it's, well, these may be some good things that need to be done, but they need to come from the legislature.
Well, you know, I wish the legislature would address these things. No question about that.
Me too.
Yeah, but the real deal is the courts can, and the courts have a responsibility. The courts are here to protect our First Amendment rights, their rights, other rights, and there's nothing. I mean, among our most important is absolutely the fact that votes are counted properly, and especially now. You know, I was thinking about a Chinese proverb that said, may you live in interesting times, and we do, and we all can see in the future there's this problem that needs to be dealt with, and this problem, and that problem, and that problem, and the way we resolve these things in our democratic system is through ballots, and to have and our social compact says, okay, we vote. The majority wins, and then they get to execute, and they get to put their program. That's how we do things in our country. And if you don't have confidence in it, and it isn't accurate, then you lose the whole thing. It absolutely is fundamental. And so we want the ability to prove, and we certainly will, that I mean, we think everything we've looked shows that the RTA election was rigged and the ballots are still there. So we'll be able to.
Wasn't there an investigation here, though, by the Attorney General's office?
Yeah, I don't. There's, of course, no evidence of this anywhere in the record. But yes, the Attorney General did pick up some ballot boxes, and there were entire precincts missing. There's substantial evidence that the boxes had been stuffed, that there were different kinds of ballots in there. It's a simple matter. If the ballots show that it passed, then that's that. I mean, that's the end of it. This is a case, it's interesting to me because it's gone on so many years, and the courts in Pima County haven't let us put on evidence to show. And the Pima County, they haven't had to file an answer yet. but it can be settled, and there's no problem with the public. Everybody can feel good about it by simply checking the ballots down the line, because we believe that that they've been in the control of the county and in the control of other folks, and that it didn't pass. So maybe when the proof comes down, we're wrong. We think there's substantial evidence, and our obligation as a political party is to do what we can to see that elections are honest and votes are honestly counted, and that we can have confidence in the results.
Well, I'm a little bit confused in terms of what was the scope of what the Attorney General was looking at. Was it just counting ballots? You're suggesting that there should have, the scope wasn't broad enough, or that they didn't do a good enough job with what they were doing? What are you suggesting should have been done differently by, or should the Attorney General have been involved?
Okay, I'm going to point out this stuff isn't in the record. So, but what we wanted the Attorney General to do was to simply, the county has a machine where they can print their own ballots. It's called a ballot on demand system, where they use a high-speed laser printer. The original ballots were printed on an offset press. What we asked the Attorney General to do was simply to take a hand lens and confirm that the ballots they were counting were printed on an offset press. We had one request, and the Democratic Party had that request. The Democratic Party Executive Committee, when Attorney General was going to run for governor, had one request. He wouldn't do it. He wouldn't do it. And he said that the reason he didn't is because of the expense involved. And there was someone up there with a microscope during that entire counting process. So it's something that we don't have confidence in, and it was a very simple thing that we wanted, and I believe that he didn't have confidence. I don't know why he didn't do it. I'm not asking you to accuse anybody. I'm just saying we believe we have substantial evidence, and we want the ability to prove it, because we need to do that to protect the ballot. And we want the legislature, we want somebody else to do it. But we're here in court. In court's the one place a political party can come and try to get this resolved. I'd like to save a couple minutes if I can. Thank you.
Thank you.
Good morning. May it please the court, I'm Ronna Fickbohm, appearing on behalf of Pima County Appellee. And I thank you for the opportunity to respond to your inquiries. Probably as an advocate, I shouldn't start by confessing error, but I would like to point out one mistake with my brief. In my brief, I said that Judge Harrington, in ruling on the RTA's special action request to obtain the ballots as public records, ruled that the ballots were not public records. What he ruled was that they were not available through a public records request under Title 39. The RTA had wanted the ballots so that it could put the controversy surrounding the election to rest and proceed about its business. This case is not about whether voting is important or whether the integrity of elections should be protected. I think everybody in this room agrees on both those points. The issue here is, first, when the legislature has chosen to act and makes a substantial, and it is substantial, body of law govern elections and electors, as we see in Title 16.
What if it's not good enough, though?
If it's not good enough, then people need to go back to the legislature and ask them to fix it. If it's not good enough because it's contrary to the Constitution, then you file a lawsuit, as we see often happens, saying you can't enact the statute, it's unconstitutional, or you can't enact the statute, it's contrary to existing law. But what you can't do is say, I don't like what you did because I think you should have done it better. Let me give you an example. I have a necklace stolen from me that was my great-grandmother's, and it's worth about $500. But to me, it's like worth everything. And I go to court, and I've got my victim rights, and I say to the prosecutor, how can this person be prosecuted for a misdemeanor? That's the last thing I had from my great-grandmother. This should be a felony. And the prosecutor says to me, but Ronna, here's a statute, and it says that it's got to be at least, I forget, it's been a long time since I was a prosecutor, $1,500, $1,800 to bump it up to a felony. So unless it's that, and I'm like, well, can't you ask the judge to change that law? Like, what if the law says if it's worth at least $500 and is irreplaceable?
But they're not asking us to change the law. I think they're asking us to supplement or add to. So
well, that would just be a supplement.
A little bit different.
It's worth $500. It's if it's worth $1,500, it's a felony, or if it's worth $500 and is irreplaceable. And that's really what they're asking. There is a statute. I think it's 16602. It's in the briefs that provides for a hand audit. And that was put into place really after the May 2006 election as part of the Election Integrity Committee and the Democratic Party's advocating, where there are certain hand auditing allowed. It's not as extensive as the Libertarian Party would like, but I don't think that you can start coming to courts and saying, well, the legislature enacted this law, but we think that they should have added a little more to it, or there should be another sentence in it, or it should be tweaked this way or that way, because then you run into, Article 3 of the Constitution, which says that the powers of the government of the state of Arizona shall be divided into 3 separate departments, the legislative, the executive, and the judicial, and except as provided in this Constitution, such departments shall be separate and distinct, and no one of such departments shall exercise the power properly belonging to either of the others. And I think that that's the problem, is that the remedy here is to take these complaints about how 5 days isn't enough to initiate an election contest. That law was probably put into place when there were, a quarter number of the people in the state that there are now, and a lot less ballots to count. Those complaints should be taken to the legislature, or should the courts say, the legislature said 5 days, but we're going to say 5 days if you live in one of the outlying counties, but if you're in one of the big counties, we're going to say you get 60 days. I just don't think that, I haven't seen any case law saying that the courts can start with that kind of tinkering and rewriting of the statutes, and that really is the heart of what this case is about. I think I cut you off.
Well, I guess I'm a little confused with your hypothetical, for example. There's no question about the facts that the necklace was stolen. I mean, isn't their issue here is they're not sure of the facts because they haven't been able to do the discovery? And does that change the analysis for you at all if they're not sure at this point what the remedy is because they haven't had a chance to figure out if there is a problem with the black box? Is that?
I think that Judge Jamil, and I apologize if I pronounce that wrong, given my Gimmel. Okay, everybody pronounces my name wrong all the time, so I'm pretty sensitive. I think he invited Mr. Reisner to say that they needed to do discovery to figure out what their remedy might be, and Mr. Reisner said no. The discovery they want to do is to prove that the May 2006 election was fraudulently obtained, because that's the first step in putting together a claim for injunctive relief. But they already know what they want to ask the court to order Pima County to do. They put it in their disclosure statement, which I made part of the record. Here, they want the graphic scanning with the images released to the public, and they also, as suggested, I think, in their motion for a new trial, would like to increase the type and amount of auditing that's done. They want the ballots segregated a way that the legislature hasn't said that they would be segregated. They really have never said that they need to do discovery to figure out how the court should tell the legislature to do it better.
The graphic scanning sounds like a good idea. Let the sunlight of public information shine on in.
And I can't tell you that personally I disagree. The problem is that when you look at ARS section 16624, it basically, that's the disposition of the official returns and ballots section. And that basically says that after the canvass has been done, and the statutes leading up to this are very precise about how the ballots are handled up to the time of canvass, they're put in an envelope that's sealed. The package with the envelope is turned over to the officer in charge of the elections. to be managed by the county treasurer, who shall keep it unopened and unaltered for 24 months for federal elections, 6 months for other elections, at which time he shall destroy it without opening or examining the contents. And the only exceptions for that are if a recount's ordered or a contest is begun. The legislature itself recognized that there's no ability to access the ballots other than that when they put the scanned ballot election auditing pilot program into place, and that's in my briefs also. I noted
2011.
I noted it as HB something, but now it's laws 2011 chapter 332 section 28. Which basically, a subsection B says, notwithstanding ARS section 16-624, on request, the county treasurer shall release the ballots to the custody of the Secretary of State pursuant for the purposes of the pilot program. So I think the legislature recognizes itself that it created this box that you really can't access these ballots by Arizona law. Now, to do graphic scanning, I think that you would have to go back to the legislature and say there needs to be another exception. In your procedures of how the ballots are handled after the elections, we need you to write in some extra steps, including this graphic scanning.
But we're not, excuse me for interrupting, but I'd like to continue the discussion of whether this is a matter for the legislature or the courts or possibly both. They're not coming in and saying, you know, we think the legislature was inadequate and we want you to do more. They're saying more than that. They're saying we have an election that we can show was rigged or that somebody cheated on, and we know what human nature is, and most of us recognize that as well. The temptation is great if the ability to do it is there. So why doesn't that shift it out of being merely a matter for the legislature and bring it back into being a matter for the court?
Well, number one, I would disagree with their proposition that you're going to sit here and assume that the election was rigged and that the facts of the Attorney General's review are not part of the record. At IR 174, which was my reply in support of the motion to dismiss, Exhibit C, I printed out the public records that are available to show the results of that review. Mr. Reisner's recitation of all the problems with that review are not supported by any record citation or other facts. And if you look at the Exhibit 1 or A, I forget which it is, the first exhibit that's attached to the Libertarian Party's counterclaim. It's a letter from Mr. Reisner sent on behalf of the Democratic Party to Terry Goddard as the Attorney General saying, you need to do a hand count of these ballots. And if you do a hand count of these ballots, this will put the issue to rest. They did that hand count of the ballots, and then the Democratic Party dropped out of this action. So starting with the proposition that there's a problem with that election, so the court should go tinkering with the statutes, isn't something that I can necessarily agree is the flow of this case. The other problem—
Can I interrupt just briefly? Was the result of that investigation that that there was no problem, or that there may have been problems, but it wasn't enough of a problem to have changed the outcome of the election?
The hand count almost mirrored the voting tally. It was off by slight percentages so as to be statistically irrelevant. It confirmed the election. And if you look also at IR Index of Record numbers 98 and 99, that's the RTA and Pima County either withdrawing or amending their responses to the Republican Party's motion for judgment on the pleadings. The Republican Party came in and said, look, Judge, there's nothing to talk about here. In response to the declaratory judgment action that the treasurer filed saying, should I destroy or should I keep? The Republican Party came in and said, there's no question here. ARS 16-624 says destroy. And the RTA objected and said, no, everybody's wondering if we're valid or not. Give us the ballots and let's put this to rest. And we said, you know, while there's this question of these allegations of criminal conduct, et cetera, we don't think you should destroy them. When the Attorney General's office finished the review, RTA said, fine, we withdraw our objection. Pima County said, we're modifying our response. So you really have that showing up three different places. Mr. Reisner's not accurate when he says that that's still an outstanding question. The other thing I'd like to point out, just in response to your inquiry about, why can't we just do this graphic scanning because it looks like a good idea. If you look at the penal provisions of Title 16, which there's a whole bunch of, ARS 16-1018 subsection A4 prohibits showing a voted ballot so as to reveal its contents. So if you did graphic scanning without modifying that, every one of those ballots that was scanned and that was put in the public record, I can't remember if that's a misdemeanor or a felony, but it's in the penal provisions. The one thing I really want to emphasize here is that...
How can you have a recount if that's the case?
What's that?
How can you have a recount?
Because ARS 16-624 subsection D and related statutes provide specifically for a recount to be done in a very specific way. The ballots are given to the judge.
It's an exception to the criminal...
Right, and basically the ballots are turned over to a judge, so we don't have to worry about, and the judge, we all would hope, is going to make sure that the individual ballots aren't revealed to members of the public so that people know how I voted in the election. Because that's really what we're talking about here. Should people be able to know how I voted in the election?
My wife doesn't think all judges are perfect.
No comment.
His wife is right.
I'd just like to point out that if you really spend the time, even just looking through the table of contents of Title 16, it is one of the most comprehensive bodies of law in Arizona statutes. There are, I kind of summarized it in the front, there are 8 chapters, at least 39 articles. If you look at 2 of those chapters, just 7, the penal provisions, and Chapter 4, the conduct of elections, you've got over 200 individual statutes, not including subsections. They regulate everything from what machines can be used, what the paper for the ballots is supposed to look at, like what poll workers can or can't do. It's highly regulated. Does that mean the courts can't ever get involved in it? Absolutely not. Let's say that a county official is refusing to follow the statutes and do what the statutes say they're supposed to. Mandamus action, require the county official to do what they're supposed to do. Let's say that the legislature enacts a statute that's unconstitutional. You challenge it as being unconstitutional. Let's say that a county is locking up an election place until the minute that the election starts so that the workers don't have a chance to get in and set up to do what they're supposed to do. Then you come in and you ask for an injunction. You say, Pima County's getting in the way of us getting in the room to do what we have to do to get this election going. And they said they're going to do this every year. Then you can do an injunction. But you can't use an injunction to say, hey, judge, I've got a better idea about how the statute should read than what the legislature's done. My people are smarter than the people that talked to the legislature in the first place. You need to amend this statute by way of judicial activism, which is, I think, what we're talking about.
If in a previous decision by a different panel that said this is an election case, what's your perception of this sort of case that this is currently? Wasn't a challenge to the 2006 election.
When I first looked at it, that's what I thought it was, and that's what Judge Harrington thought it was. If you look at how it's pled, it's sort of hard to tell exactly what it is. Okay. I mean, it basically says there's substantial evidence that the RTA election was procured as a result of fraud. Judge, we want you to give us the ballots, which the statutes say you can't do. And we're going to look at them, and we're going to come back to you and ask for a hearing. And if fraud is shown, then we're going to ask you to do something about it. That's all it says. I'm not sure what kind of an action that is. I thought it was either a request to participate in a criminal prosecution that the Attorney General's office wouldn't do at the time when it was filed. The Attorney General's office hadn't undertaken the recount yet. Or an election contest. So I filed the first motion to dismiss. In response to that motion to dismiss, for the first time, the Libertarian Party piped up and said, no, we're just looking for prospective relief. That's all this is about. So the Court of Appeals sent it back down and said, well, we don't know if it's a valid claim for prospective relief because the trial court really didn't look at that. So trial court, you can look at it now, leading to my second motion to dismiss, leading to us being here today. If there were a couple other things I wanted to correct quick before I run out of time. that were asserted in the reply that I didn't have a chance to respond to. One of those was that it's easier to cheat now than it was in 2006. You'll note that no record citation accompanies that, and actually I think that's absolutely contrary to the facts that were provided by way of, I think, Exhibits F and G to the reply, my reply in support of the motion to dismiss IR 174, where in the database action that preceded this, the judge actually praised the Democratic Party for working with Pima County to put a bunch of changes into place to improve election integrity. They say Pima County won't deny it rigged this election. Absolutely untrue. If you look at one example would be the transcript of the hearing you have from May 5th, 2012 at page 22. There's an outright denial of that. They say Pima County through Mr. Huckleberry has systematically subverted critical controls required to protect the integrity of elections. There's no record citation. That's ridiculous. And now Pima County agrees that elections can be rigged. I just like to remind the court that what they pulled that out of is the database action, and the Pima County Attorney's Office was representing Pima County then, and their concern was that if you took the data out of the secure environment it was in and sort of put it out there in the world, that that was going to compromise integrity. The bottom line is the cry here is who will protect the purity of elections. I would point out to you that, number one, there's criminal enforcement. ARS 16-1011 makes counterfeiting of ballots a Class 3 felony. That's pretty serious. ARS 16-1004 makes interfering with the machines a Class 5 felony. And again, if there is a problem, it can be brought to the Attorney General's office. If they think the time period for election contests is too short, you go to the legislature and you ask them to extend it. If a public official is not following this hefty body of law that the Secretary of State under the legislature's authority has established, you bring a mandamus action asking them to do what the statutes say they should, or you go to the legislature and ask them to change the statutes. Council makes a lot of passionate statements about the importance of elections. We all agree about that. The facts that do exist in the underlying record do support what the trial court ruled dismissing, and so does the separation of distribution of powers in Arizona's Constitution, as well as the limits that the legislature has placed on political parties. If you look at ARS section 16603, that talks about the ability of political parties to view ballots, and it's very specific that they can't touch them or take possession of them. The legislature has spoken. Political parties can look at ballots, as we say in ARS 16-603, and that isn't turning them over to them so that they can do their own examination and their own recount, which is really what they want to do here. Thank you, Your Honors.
Thank you.
Yeah, thanks. I want to be clear, the ARS 16-602B, which provides for some hand counts, does not include county races. So when counsel says that there's some auditing, hand auditing, there are none for county races. And Pima County's election director lobbied to make sure that that wasn't part of the statute. She cited 16-1018, ARS 16-1018. That relates to polling place conduct. That doesn't relate to whether or not ballots can be could be scanned. But again, that's not something that was really argued or dealt with in the record below.
Can I just clarify, so is your client okay then with the procedures in place for statewide elections? You're only focused on the Pima County elections?
Well, that's what this lawsuit's about, but the Libertarian Party had filed a lawsuit in Maricopa County for various... But
I guess my question is, would you be... They're comfortable with the protections that are in place for the... you're saying that only apply to statewide elections? And you're saying those need to be in place for county elections?
We're not comfortable with the computerized elections and the protections anywhere in the state of Arizona, but what we have here is we have a situation that is somewhat unique, where we can show that in fact they took the bait, and I want to point out, this is a 12b6 stuff. This is everybody. It's assumed that we can prove it. It's assumed that they did it. That's the predicate that enables us to say, okay, they did it and they can repeat it, and here's some steps that can prevent that. And it would be wonderful if that could become a model and protect all people across the state, but that's not this case. And the suggestion that this whole body of election law is some well thought out thing is far off the mark. Our election statutes are kind of a hodgepodge, because you look at 16601, they count the ballots right there in the presence of bystanders, continue without adjournment till completed, and results determined and declared. That's the way it always happened in Arizona. Then they got machines, then they got levers, then they got computers, and so the election laws are not a well thought out scheme to protect everything. That's simply not the way it is, and that's why, because of computers and because of the evidence that we have, and it's undisputed. I've filed a bunch of stuff in the response to the amicus brief. I've got a couple of affidavits by experts. It's a whole new thing with computers and the secrecy of these ballots and protections need to be there. And with our situation in Pima County, we need the ability to be able to put on the evidence to show a judge, look, here's what the problems are, here's what the answers are, and hopefully get a good ruling that will protect this democracy and protect the accuracy. It's extremely important, and we entrust the decision to y'all. Thank you.
We appreciate the argument of counsel in this matter. We will take the issue under advisement and issue our written ruling in due course. Until then, we stand adjourned. Thank you.